This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position. This meeting is private, bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of a federal, state, province, county, city, township agency present? This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position. One last time. This meeting is private, bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of a federal, state, province, county, city, township agency present? This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position. Okay, that's great. We're clear, and we'll open up our meeting with a short prayer. O Holy Father, bless our meeting with eyes to see and ears to hear. The messages and info being presented with an open and caring and compassionate heart for all our fellow and brothers and sisters to see, as it may be done. Take it away, Glenn.
Thank you, Lori. I think it's a great idea to start with a prayer, that's for sure, because it gets the spirit in the right place. I'm going to cover, I've deleted a bunch of my lawsuit. I was actually going to file it here, before I left Texas. I am currently in a hotel in Arizona, but I'm planning on leaving, checking out tomorrow morning and heading to Texas. So I'll be back in Texas here pretty quick. I came to Arizona to take care of some business. That's why I actually left last Friday. And so that's why I wasn't able to be on the call last weekend. And so what happened is I sent this thing to Randy Kelton. I don't know how many of you know who Randy Kelton is. He's a talk radio host. He's ruleoflawradio.com. He's been on there for many years with a guy by the name of Eddie Craig, who's a former county sheriff for Austin. I think he's Austin. He's a former deputy sheriff, and they're strictly statutory. Okay, you have to understand that they deal strictly in the statutes. But I've been talking to Randy. I see him probably a couple times a week, actually, and sometimes we go out to dinner, and so we kind of hobnob quite a bit. And I sent him my lawsuit, and he basically criticized it substantially, called it word salad. But he did tell me, and I told him I'm interested in any constructive criticism he might have. And so he did tell me to order a couple books. One is O'Connor's Civil Trials and O'Connor's Causes of Action. And he said that it would help with, writing my lawsuits. And so I did. And they're sitting in Fort Worth waiting for me to pick them up when I get back. So I've been kind of massaging this thing over the last week, and I deleted some of the stuff out of it for this presentation just because I didn't want it getting out, some of that stuff that I brought up or am planning on bringing up. And even after I deleted stuff out, it's still like 60 pages. But so I figured we'd go through a bunch of it and why, I have it in there. Randy said that he what I consider a compliment, because he's strictly statutory and he doesn't go into the kind of arguments that I make, but he said that the issues I'm bringing up are brilliant, and he said that these lawyers don't have a clue about this stuff, and he said that if I can put it together in a good lawsuit, he said I am going to kick their butts around the block. So anyways, yeah. He
nice
liked
feedback.
Sorry.
That's nice feedback.
Yeah, for sure. It's certainly constructive. It's I'd call it constructive feedback for sure. But yeah, so there's some of the stuff I've talked to him over the years, like using without prejudice, and I talked to him about that, and he said that was the first time anybody ever gave him a logical explanation about when to use without prejudice that made any sense. And so he liked it. And I've got that in here, actually. I've got that in here. So anyway, so what I was going to go through is breeze through some of this stuff, because I've been doing some research and why I put some of the stuff in here that I did. So I make it in the form of an affidavit. I always do my lawsuits that way, in the form of an affidavit. And so I start off with, I, the demandant herein, hereby affirm the following facts, and it doesn't matter who's on there. And I make this affidavit because the military police are peddling lies and disinformation for their communist agenda to create civil war for their communist handlers, terrorizing the people of the Republic of Texas, because they intend to create the scenario so they can murder the demandant and create business for themselves, because they hate anybody who thinks they have any rights. Demandant has no first-hand knowledge of the date of birth. Now, the reason I put this in here, and you all, if you're going to do a lawsuit, you need to keep this in mind. They need to know that you're old enough to make an affidavit. Okay, you got to be older than 18 years. Otherwise, it's going to be like a waste of time. And so that's why I put this in here. I'm not going to give them a date of birth, because if you give them a date of birth, then they can pull up the minor estate account. Okay, and so I just tell them I remember finishing high school in 1975, which means that's over 50 years ago, which means I'm well past the age of majority. And so it's up to you how you want to do that, but they need to know that you're old enough to make an affidavit. So my mother was into genealogy and done extensive research on ancestry to the point she discovered that Will Livingston, who ratified the Constitution for New Jersey, was my fourth great uncle, which means on posterity is found on the preamble, and I'm entitled to right of blood, and the maxim of law, no civil law can violate right of blood. Bouvier's Law Dictionary. And these military police are operating under a power which is derived from me as posterity. And the maxim says the power which is derived cannot be greater than that from which it is derived. So they're usurping some sort of authority here is what they're doing. Further elaborated in the U.S. Supreme Court case, not because of any formal conception or obsolete theory, but on the logical and practical ground that there could be no legal right as against the authority that makes the law on which the right depends. This court has jurisdiction because it's involving war crimes against the demandant and the people of the Republic of Texas, and because of the Republic of Texas. This court has jurisdiction because the wrongdoers named herein are depriving the demandant and the people of the Republic of Texas of U.S. constitutional federally protected rights, including but not limited to the right to pursue happiness, the right to get compensation for labor, the right to engage in constitutionally protected activities like conduct a common law court, the right to seek a redress of grievances, the right to exhaust administrative remedies, the right to due process of law, and the right to life, liberty, and the pursuit of happiness is found in the organic law of the Declaration of Independence. And, things like this word, this phrase right here, that's very important, okay? Organic law, the Declaration of Independence is the organic law. That's the law, the real law. That's the real law in this country. The wrongdoers in this case are operating under color of law to violate the defendant's right to self-determination, to be a Texas national, as well as the right of the people of the Republic of Texas to self-determination, to be Texas nationals, guaranteed by the International Covenant on Civil and Political Rights, as well as the 1933 Montevideo Convention on the Rights and Duties of States, both of which have been acceded to as treaty law by the U.S. Senate. And so this, both of those, are important, and we all should become familiar with them and what's in them. That rights and duties, especially if you're in Texas, this 1933 Montevideo Convention on the Rights and Duties of States. This is something that someone brought this to my attention here, and I found out about it here within the last week. And so I've been adding this kind of stuff in there about the Montevideo Convention. The wrongdoers are setting up the demandant to murder him so they can make work for themselves, justify their job, and shed some innocent blood for their handlers. Since 2007, when the demandant became involved in the Republic of Texas, the wrongdoers have engaged in repeated, systematic, continuous war crimes against the demandant and the people of the Republic of Texas, only some of which are evidenced herein. The demandant will show the court that the state of Texas is a fictitious overlay over the Republic of Texas. The Republic of Texas was recognized by Andrew Jackson, still exists. Here, let's add this here. As recognized by Andrew Jackson, still exists. In the early 1990s, some of the people of Texas discovered this and brought the Republic of Texas out of abeyance, which is dormancy, by forming a provisional government of the Republic of Texas and started holding elections for the Republic of Texas and have been holding elections ever since. The wrongdoers have engaged in repeated, systematic, continuous violations of the demandant's common law rights under color of law with slander, defamation, assaults, false arrests, kidnappings, false imprisonments, and attempted murder since 2007 in the free exercise of his rights to engage in constitutionally protected activity under color of law. The wrongdoers are taking reprisals against the demandant and the people of the Republic of Texas for our religious beliefs to subject us to their satanic religious ceremony with their fraud, deception, necromancy, and idolatry. The wrongdoers have unlawfully arrested the demandant with a fake warrant, kidnapped the demandant, falsely imprisoned the demandant, and attempted to murder the demandant as part of the war crimes agenda against anyone who exercises their right to self-determination as a Texas national. These wrongdoers named herein and others are creating terrorists to make business for themselves and shed some innocent blood for their handlers. It's well established that military police officers like Casey Brashear, Andrea Bant, Marshall Thomas, Captain M. Lugo, and Bobby LaPena are screened for low intelligence and a propensity for aggressive behavior. See Jordan versus City of New London, U.S. Court of Appeals for the Second Circuit, number 99-9188, 2000 U.S. Appeals, Lexus 22195. Casey Brashear is purporting to be an agent of the weaponized Federal Bureau of Investigation and the Joint Terrorism Task Force, but he's never produced identification or a business card identifying himself. Therefore, he's impersonating a public servant. These military police have uniforms, rank structures, police vehicles with colors and flashing lights that are designed to be threatening and intimidating, designed to instill fear into people, which is just another reason of many that they are the terrorists. The Secretary of State is named because the Republic of Texas was recognized and still exists, and we think it would be good for everyone to enter into negotiations for a treaty of peace to bring an end to that very difficult war between the states, at least as far as Texas is concerned. And the demandant tried to get the president of the Republic of Texas to send Donald Trump a proposal, but after Brashear's malicious prosecution and previous malicious prosecutions with Susie Kamak, as described herein, they're all hiding for fear of being maliciously attacked. So, and then the history. In the year 1861, the southern states walked out of Congress, and Congress ceased to have a quorum to conduct business and could not conduct business. On the 15th of April, 1861, Lincoln ordered Congress to reconvene under executive authority with Executive Order Number 1 at 12 Stat 1258, and they've been operating under executive authority ever since. The southern states that walked out of Congress became the Confederate States of America, and the war between the states was started. In the year 1871, while operating under executive authority, Congress authorized a municipal corporation to operate in the District of Columbia at 16 Stat 419, which is talked about in the dissenting opinion of Downs versus Bidwell, 182 U.S. 244, 1901, as the second national government that's maintained by Congress outside and independently of that instrument, the Constitution. And this is the quote: two national governments exist, one to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. That the military police, Casey Brashear, Andrea Brandt, Marshall Thomas, Captain M. Lugo, and Bobby LaPena are conspiring together with bar members Leah Simonton, Kelly Higgins, and Phil Sorrells to work for, in violation of their oaths to support and defend the supreme law of the land, Article 6, Clause 2. So this goes into the Republic of Texas now. The state of Texas is one of the Confederate States of America, and technical state of war still exists between the United States and the Confederate States of America because there's been no treaty of peace. But there was an armistice, which is a ceasefire only. In the year 1863, Lincoln asked Harvard law professor Francis Lieber to write the law of war for the U.S. Army, which became known as the Lieber Code, but was actually designated General Orders 100, all of which is now included in the United States Law of War Manual that is now a book about 4 inches thick. The state of Texas is a military government put in place by the United States Army under Article 1, General Orders 100, the Lieber Code. A place, district, or country occupied by an enemy stands in consequence of the occupation under the martial law of the invading or occupying army, whether any proclamation declaring martial law or any public warning to the inhabitants has been issued or not. Martial law is the immediate and direct effect and consequence of occupation or conquest. The presence of a hostile army proclaims its martial law. The martial law continues to this day under Article 2, General Orders 100, Lieber Code. Martial law does not cease during the hostile occupation except by special proclamation ordered by the Commander-in-Chief or by special mention in the Treaty of Peace concluding the war, when the occupation of a place or territory continues beyond the conclusion of peace as one of the conditions of the same. Because there's been no special proclamations by the Commander-in-Chief, who's the President of the United States, and there is no Treaty of Peace to this date. The Republic of Texas recognition. President Andrew Jackson officially recognized the Republic of Texas on March 3, 1837, which was also recognized by France, December 25, 1839, and other nations, including Belgium and the United Kingdom. And the defendant has visited the former embassy of the Republic of Texas in Paris, France, that's now being used as a hotel. And it's true, I was there. I got pictures of it. The 1933 Montevideo Convention on the Rights and Duties of States was ratified by the United States as a treaty and entered into force on December 26, 1934, which requires that recognition is irrevocable. So they recognize the Republic of Texas, and they can't all of a sudden unrecognize it. In Article 6 and Article 8, no state has the right to interfere in the internal or external affairs of another state. And further evidence of the war crimes being engaged in by these military police, Casey Brashear, Andrea Brandt, Marshall Thomas, Captain M. Lugo, and Bobby LaPena, who are conspiring together with bar members Leah Simonton, Kelly Higgins, and Phil Sorrells to threaten, coerce, injure, and intimidate the people of the Republic of Texas in the free exercise of our rights to engage in U.S. constitutionally protected activities of common law courts and petition the military government for redress of grievances in support of our right to self-determination and our right to determine our own political status as Texas nationals. The state of Texas joined the Confederacy and Union in the year 1845. Okay, that's when Texas joined the Union. The state of Texas joined the Confederacy and Union under the Articles of Confederation and Perpetual Union of 1781. Okay, that's the Articles of Confederation. It's commonly called the Articles of Confederation. as evidenced by Act of Congress at 9 Stat 1, and still exists as evidence by HJR 1, dated 29th of December 1945. Quote, the territory properly included within and rightfully belonging to the Republic of Texas was erected into a new state to be called the state of Texas, on an equal footing with the original states in all respects whatever. So they're talking about the original 13 states. All on equal footing with the original states. That means the Articles of Confederation. With a Republican form of government, as found in the Act of Congress, December 29, 1845, at 9 Stat 1, and this is the preamble for the Act. Be it enacted by the Senate and House of Representatives of the United States of America and Congress assembled, that all the laws of the United States are hereby declared to extend to and over, and to have full force and effect within, the state of Texas, admitted at the present session of Congress into the Confederacy and Union of the United States. And that might seem, it's hard to say whether you would consider that important, but when you read this House Joint Resolution, it becomes very important. And this is the House Joint Resolution dated 29 December 1845 at 9 Stat 108. So a joint session approved March the 1st, 1845, did consent that the territory properly included within and rightfully belonging to the Republic of Texas, so they're saying the territory that is the Republic of Texas, might be erected into a new state called the state of Texas, with a Republican form of government. And it's hereby declared to be one of the United States of America and admitted into the Union on an equal footing with the original states in all respects whatever. Okay, so they're talking about the Articles of Confederation. Because normally when one sovereign nation joins another sovereign nation, a treaty of annexation is done, which was done by the Republic of Texas and sent to the U.S. Senate for approval and adoption, but it was shelved. They didn't approve it or adopt it, they shelved it. And the state of Texas was created under the Articles of Confederation and Perpetual Union, 1781, under Article 9. It says, we'll start here, the underlined part. But no colony shall be admitted into the same unless such admission be agreed to by 9 states. Okay, so that means a House Joint Resolution, which is why a House Joint Resolution is all that was used. And the state of Texas is an entirely different entity from the Republic of Texas. And the Texas territory is properly included within and rightfully belonging to the Republic of Texas. They're admitting right there by those words that the Republic of Texas still exists. Therefore, the state of Texas is a fictitious overlay over the Republic of Texas, and the Republic of Texas still existing, with the Republic of Texas still existing. State of Texas military dictatorship. Under HJR 1, 29 December 1845 at 9 Stat 108, the state of Texas is required to have a Republican form of government. It's required in the Constitution as well. And it's impossible for a military government operating under martial law to be a Republican form of government, because the military government is a dictatorship, as evidenced by Article 3 of General Orders 100 Libra Code. Martial law in a hostile country consists in the suspension of by the occupying military authority of the criminal and civil law and of the domestic administration and government of the occupied place or territory, and in the submission, in the substitution of military rule and force for the same, as well as the dictation of general laws. That's like dictatorship, folks. As far as military necessity requires this suspension, substitution, or dictation. The commander of the forces may proclaim that the administration of all civil and penal law shall continue either wholly or in part, as in times of peace, unless otherwise ordered by the military authority. So, first of all, they don't want you to know that you're under martial law. They don't want you to know that it's a dictatorship, because the people will revolt. And so they want you to think that everything is normal. So they'll never let on. But this is what the Libra Code says. And because the Republican form of government requires law of the land and common law and political power to be in the hands of we the people, and a symbolic military government called a democracy, with all state of Texas employees, including all of the wrongdoers named herein, being quote-unquote federal personnel, as required by their Roman civil codes, 5 U.S.C. section 552 AA 13, which is anyone with a social security number. Okay, the term federal personnel means officers, employees of the government of the United States, members of the uniformed services, individuals entitled to receive immediate or deferred retirement benefits under any retirement program of the government of the United States, including survivor benefits. That means anyone with a Social Security number is quote-unquote federal personnel. For their 1871 municipal corporation at 16 Stat 419, civil law, Roman civil law are convertible phrases meaning the same system of jurisprudence, that rule of action which every particular nation, commonwealth, or city has established peculiarly for itself, more properly called municipal law. That exists today as the second national government talked about in the dissenting opinion of Downs versus Bidwell, that is maintained by Congress outside and independently of that instrument, the Constitution. Maybe I'll just add that in here. Justice. And is a military dictatorship, and the United States has failed to provide a Republican form of government as required by Article 4, Section 4. Article 4, Section 4 of this Constitution for the United States of America, the United States shall guarantee to every state in this union a Republican form of government. So they're required to provide a Republican form of government, and they've failed to do it. Unless, of course, they want the Republic of Texas to take care of that for them. Except that the Republic of Texas is that Republican form of government, but is being maliciously attacked by the military police, Casey Brashear, Andrea Brandt, Marshall Thomas, Captain Lugo, and Bobby LaPena. And matter of fact, I might even just add in here. By the Screen for Low Intelligence military police, who are conspiring together with bar members Leah Simonton, Kelly Higgins, and Bill Sorrells. The Republic of Texas was brought out of abeyance after the war between the states and its armistice, ceasefire. Maybe I'll add that in. Whoops. Many years have passed, and all those involved on both sides are now dead. And in the early 1990s, some of the people of Texas, after reviewing the Act of Congress at 9 Stat 1 and Resolutions HGR 8, March 5th, 1845, 5 Stat 797, HGR 1, 29th December 1845, 9 Stat 108, of the U.S. Congress and other historical evidence, discovered that the Republic of Texas was in abeyance or dormancy as an entirely different entity from the state of Texas, and the Texas territory is properly included in and within and rightfully belonging to the Republic of Texas, and brought the Republic of Texas out of abeyance and organized provisional government of the Republic of Texas and held elections, and have been holding elections ever since to peacefully provide common law remedies to the people of Texas. The Republic of Texas is a foreign government under 18 U.S.C. Section 11, irrespective of recognition. And that's 18 U.S.C. 11, that's what this is. Because the first thing state of Texas actors say to us is, we do not recognize you, speaking of the Republic of Texas, even though it's the same Republic of Texas that was recognized by President Andrew Jackson, March 3rd, 1837, which was also recognized by France, December 25th, 1839, and other nations, including Belgium and the United Kingdom. See, all you need to do is get 3 other nations to recognize you, and then you're a recognized nation under international law. The Republic of Texas is a group of men and women on the territory properly included within and rightfully belong to the Republic of Texas, trying to peacefully bring the common law remedies to the people of Texas as a Republican form of government, because the state of Texas is a military government operating exclusively under martial law as a military dictatorship and can never be a Republican form of government. Even though the demandant has resigned as a senator, the demandant can say with some authority, after being involved with the Republic of Texas government for almost 20 years, that the people of the Republic of Texas would very much like to enter into a treaty of peace with the United States and bring to an end the war between the states as far as Texas is concerned. We believe it would be good for everyone, and maybe other states formerly part of the Confederate States of America would like to do the same. It would be very good to bring that dark chapter of our history to a final conclusion. In the year 1995, the Supreme Court of Texas dismissed a case involving the people of the Republic of Texas for lack of jurisdiction. Case 95-1002, styled In Re, the People of the Republic of Texas, by and through Richard L. McLaren, their legal diplomatic representative as acting ambassador and consul general and legal affairs officer for the Territorial Land District. Et al., evidencing that they know they have no authority over the people of the Republic of Texas.
When you need a space between 30 and the word in.
Space between where?
The number 30 and the word in.
You know, that's automatically done by Word for some reason. I'll put it in there, though. That's a good idea. Word did that. I probably need to go through here and do that and all the rest of these too then. Yeah, I noticed that before, but I figured that since Word was doing it. But you're right. Anyways, okay. Well, that's good to know. The U.S. Congress and the President of the United States have acceded to the International Covenant on Civil and Political Rights, 9 June 1992, and is now supreme law of the land as a treaty under Article 6, Clause 2. And we, the people of the Republic of Texas, have the right to self-determination and the right to determine our own political status as Texas nationals. Therefore, we're engaging in U.S. constitutionally protected activity, and Casey Brashear, Andrea Brandt, Marshall Thomas, Captain Michael Lugo, Phil Sorrells, Leah Simonton, and Bobby LaPena are conspiring together to threaten, coerce, intimidate, and injure we, the people of the Republic of Texas, in the free exercise of our right to self-determination to determine our own political status as Texas nationals for our Republican form of government guaranteed under Article 4, Section 4. The United States shall guarantee to every state in this union a Republican form of government. The demandant has never in his life breached the peace, but Casey Brashear, Andrea Brandt, Marshall Thomas, Captain Michael Lugo, Phil Sorrells, Lil Simonton, Kelly Hagan, and Bobby LaPena and their military police breached the peace on a routine basis with their unlawful false arrests, false imprisonments, kidnappings, attempted murders as described herein, and they've slandered and defamed the demandant in countless ways as described herein and demonstrated that they want the demandant, anybody who thinks they have common law rights, dead, because they're doing exactly what Lieutenant General Michael Flynn, U.S. Army retired, says the U.S. Army does to an enemy in his book, The Citizen's Guide to Fifth Generation Warfare, Session 1 and Section 3-3, First, they polarize the enemy. Second, they tribalize the enemy. Third, they dehumanize the enemy. And finally, fourth, they kill the enemy, which is their objective for the demandant. They intend to murder the demandant. They have already attempted to murder the demandant. They've slandered the demandant, defamed the demandant to the point his own sons and daughters do not talk to him, and have demonstrated that they intend to continue it, to create terrorists so they can shed some innocent blood for their handlers and justify the demandant's murder until the demandant does turn up dead for their handlers. Casey Brashear, Andrea Brandt, Leah Simonton, Captain Michael Lugo, and their Marshall Thomas claim we do not think the law applies to us, and that is entirely false, and evidence of their low intelligence threats, lies, terrorism, and calumny that they're peddling to generate business for themselves as part of their agenda to polarize, then tribal, then dehumanize the demandant and the people of the Republic of Texas in preparation for the fourth and final step, murder. The truth of the matter is that the Constitution, under Article 6, Clause 2, is the supreme law of the land in America, and the phrase law of the land is talking about common law. And this is actually taken from Book 16 of American Jurisprudence, Constitutional Law, Section 543. The principle that no person should be tried for life, liberty, or property, except by due process of law, did not originate with the American system of constitutional law, but was contained in the Magna Carta, sometimes referred to as Chapter 29, confirmed on 19th day of June, 1215, declared, no freeman shall be taken or imprisoned or deceived or outlawed or exiled in any wise destroyed, nor will we go upon him nor send upon him, but by the lawful judgment of his peers or by the law of the land. It has been said that the principle was known before the Magna Carta, and that it was originally designed to secure the subject against arbitrary action of the Crown and to place him under the protection of the law. It is settled beyond question that the principle came from England to America as part of the common law and has been a fundamental rule in common law. When first adopted in Magna Carta, the phrase law of the land had reference to the common law and has been a fundamental rule in common law. And common law and law of the land has always been here long before the government was here. And this is Hale versus Hinkle, 1906. The individual may stand upon his constitutional rights as a citizen. His rights are such as existed by the law of the land long antecedent to the organization of the state. Antecedent means before. So long antecedent to the organization of the state and can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are refusal to incriminate himself and the immunity of himself and his property from arrest or seizure except under a warrant of the law. He owes nothing to the public so long as he does not trespass upon their rights. Long before the government was here long before, I guess that's a little bit, yeah. And the military government is required to step aside when we the people step forward in ex parte Milligan and common laws everywhere above the high water mark and after the first bridge in on any navigable river except the District of Columbia in Article 1, Section 8, Clauses 17 and 18, and any federal enclaves. And as affirmed by Section 14 of the Organic Law, the Northwest Ordinance, 1787, that was passed just 3 months prior to the U.S. Constitution being ratified by the demandant's fourth great uncle, among others, as well as affirmed by the Judiciary Act of 1789 at 1 Stat 73, saving to suitors in all cases the right to common law remedy where the common law is competent to give it, and the Judicial Code of 1911. Of all cases, Admiralty Maritime Jurisdiction, saving to suitors of all cases the right to common law remedy where the common law is competent to give it. 36 Stat 1161, Section 256, Part 3. All of which is evidence that Brashear, Brandt, Lugo, Simonton, Sorrells, Jones, Higgins, Thomas, and their intent to perjure their oaths to the supreme law of the land. Because they're busy working for the 1871 Municipal Corporation and 12 Stat 419 under Roman canon law, which is the second national government maintained by Congress outside and independently of that instrument, talked about by Justice Marshall Harlan in the dissenting opinion of Downs versus Bidwell, 182 U.S. 244 in 1901. The minor estate, Sestake usufruct, created, so this is under the heading using Commerce Clause to bring the District of Columbia dictatorship outside a maximum of 10 miles square. The minor estate, Sestake usufruct, created by the Sestake V Act of 1666 by the Pope's owned and operated Crown of the United Kingdom and brought into the United States with the Code of Law for the District of Columbia in 1901. What I'll do is I can upload this document. I took out the stuff that I didn't want to make public at this point, so I can upload this document as a Word file to the group. And if you just remind me, I'll make sure and do that. So then you can have these court citations, okay? Because this is some really good stuff, I'm telling you. Anyways, brought into the United States with the Code of Law for the District of Columbia in 1901, Chapter 854, an act to establish a code of law for the District of Columbia, the legal estate to be the Sestake use. Matter of fact, I've actually got those actual acts, and they're probably small enough that I can, the whole book that they come out of is, probably 60 megs. But the file with just the act might be, maybe a couple megs or even smaller. So I can upload these acts to the group too. So then you can make them available, the acts themselves. Anyways, the legal estate to be the Sestake use, 1617 at 31 Stat 1432, now codified at 31 CFR 363.6. Because of the necromancy, Sestake use, usufruct. Okay, use is short for usufruct. Okay, you got to understand that. People are presumed dead at Chapter 3, absence of 7 years, at Section 252 at 31 Stat 1230, presumption of death. He shall be presumed to be dead in any case wherein his death shall come in question, unless proof be made that he was alive within that time. So they presume you're dead. And I go into this at the very end, I'm telling you. It gets, the last paragraph here is pretty good. anyways, which is now called the minor estate, 31 CFR 363.6, is an entity because an entity includes the estate of a living person, such as an incompetent or a minor. And a minor can be anyone over the age of 18 years who's failed to take control of the securities in their Treasury direct account. And that's also found at 31 CFR 363.6, which is a fiction of law which falls under Roman canon law and was invented by the Roman praetors under the pretense of doing equity and owe their origin to the legislative usurpations of the bench. And this is quoted from Bouvier's Law Dictionary, 1856 edition, volume 1, page 520. And fictions of law are necromancy and satanic. And this is Deuteronomy 18, 10 to 12, King James Version. This is all, I use the King James Version because that's the one I was raised on, and that's the one that's most widely accepted. Anyways, the other ones I'm sure say similar things. Says, there shall not be found among you anyone that maketh a son or daughter to pass through the fire, or that useth divination, or observer of times, or an enchanter, or a witch, or a charmer, or a consulter of familiar spirits, or a necromancer, or a wizard, or a necromancer. For all that do these things are an abomination unto the Lord, and because these abominations the Lord thy God doth drive them out from before thee. And puts you under the Commerce Clause, under Article 1, Section 8, Clause 3, violating Article 1, Section 8, Clause 17. And that's to exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square. And everything in the Code of Federal Regulations, including the minor estate, 31 CFR 363, is government property, too. Under Article 4, Section 3, Clause 2, the Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. So if it's in the regulations, it belongs to the United States. You got to understand that. And that's where a lot of people, they go and say, it's my estate. It's not. Okay, you might have an interest in it, but I don't want anything to do with it. But you might have an interest, but it's not yours. It belongs to the government. And the demandant may have an interest in the minor estate, but the demandant wants nothing to do with it because it's created by fraud and deception, and it's necromancy and satanic, as described herein. And the truth of the matter is that it's a badge of slavery because it's property belonging to the United States. That's why a slave is a slave, because a slave is a thing that is owned as property. And because, so if you associate yourself with it, then you just converted yourself into a slave. That's why I differentiate myself between that thing and me. And because Keisha Brashear, Andrea Brandt, Captain Michael Lugo, Leah Simonton, Phil Searles, Kelly Hagan, Marshall Thomas, and their military police are using the minor estate and the Commerce Clause to bring the District of Columbia plenary jurisdiction, which is plenary means a dictatorship, outside a maximum of 10 miles square in violation of Article 1, Section 8, Clause 17. And this is National Mutual Insurance Company versus Tidewater Transfer Company, U.S. Supreme Court, 1948. And through their plenary power nationally, covers those citizens, even one in one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. And so, that's why, remember, in the Kavanaugh hearings, I don't know how many of you remember that, they asked Kavanaugh, I think it was Lindsey Graham that asked Kavanaugh, can we go after a U.S. citizen in Afghanistan? And Kavanaugh said, yes, you can. And it's because of this, because of the Commerce Clause. Because the minor estate is a type of a trust, and a trust is property and a thing, and has no rights, and falls under Roman canon law and Keisha Brashear. So if you're gonna, that's why I say I talk about unproven theories, okay? You got to be really careful when you're dealing with this thing if you want to do anything but just repudiate it. And that's what I do, is I just repudiate it. I want nothing to do with it. And you'll see at the very end the remedy that I want. I don't want the fake money that's in the account. And I say maybe somebody can shove it up the Pope's rectal orifice, is what I say, because that's, I really don't want anything to do with it. Now, if they dissolve that thing, they'll probably give it to me, but I don't know. And I'm not telling them I want it. And you have to have clean hands. These courts are all courts of equity, and there's the clean hands doctrine. And you have to have clean hands. And so I'm telling them I have clean hands with this thing. I want nothing to do with it. You can stick it up the Pope's rectal orifice. Anyways. And his military police are all U.S. citizens of the District of Columbia as required by the Roman Civil Codes for their 1871 municipal corporation as 16 Stat 419. Civil law, Roman civil law, convertible phrases. I already read that. And because there are two national governments exist, one to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. And they intend to make sure the demandant submits to it or he will turn up dead. And then they get to pillage the fake money from the Treasury Direct account under GlennWinningham firm under the Hague Convention concerning the international administration of the estates of deceased persons concluded on 2nd of October 1973. And the demandant's not suicidal, but if he does turn up dead, this is deathbed testimony. Or the demandant will be subjected to the District of Columbia military prisons, which is exactly what has already happened as described herein with their warrants that fail to be authentic, and the District of Columbia Roman law so-called courts. Therefore, whether they enslave the demandant or kill him resisting their slavery, either way, it's a win-win scenario for Bashir and his handlers. I thought I deleted this out of there. I guess I'll delete it right now. Oops. There we go. So they issued an intelligence bulletin against me. Okay, this was back in 2010, and so when they do that stuff, they put all sorts of information in there that they obtained, and this is the arguments that you need to make. Okay, you need to bring it up and you need to make it, and if you don't, then it will presume that you agreed to it. Okay, so you got to understand that. So Texas DPS illegal searches and seizures. All the information in the Texas DPS intelligence bulletin is hearsay, including the hearsay evidence of the minor estate's name, the date of birth, the social security account number with the Treasury, and other hearsay evidence, government license plates, etc. That is evidence of an illegal search and seizure of property in government hearsay databases. Okay. The demandant neither admits nor denies the validity of any of the information in the Texas DPS intelligence bulletin. All the information in the Texas DPS intelligence bulletin is inadmissible because it's hearsay. And it is. It's all hearsay. And the demandant, because they heard it, they got it from a computer system. And who knows about the reliability of what's in that computer system? And the demandant failed to admit any of it, and all of it was obtained with an illegal search and seizure of property of which the demandant has an interest in government hearsay databases in violation of Article 4 Amendment. All databases, government or otherwise, are full of hearsay information, and the demandant requires the opportunity to cross-examine whoever put the hearsay information into the computer system to determine the veracity of that information. And nobody has produced any lawful search warrant signed by a judge acting in his official capacity authorizing the search of government hearsay databases describing exactly what they're allowed to search for as required by Article 4 Amendment. Therefore, this court is required to presume that no such warrants exist. A true copy of the intelligence bulletin is attached here too at Exhibit 3, all of which is incorporated herein by reference in its entirety, and that's true. If the evidence isn't there, if they haven't given it to you, then the court has to presume the evidence doesn't exist. And you need to bring that up. And there's some court cases, but I might have them here somewhere. But I had them. I deleted some of that stuff just now. Anyway, so let's go ahead and continue. The resolution of Congress says that because we have a Republican form of government, we're all sovereign citizens, as evidenced by House Joint Resolution 183, dated May 3rd, 1940, at 54 Stat 178, says in the preamble, whereas it is desirable that the sovereign citizens of our nation be prepared for the responsibilities and impressed with the significance of their status in our self-governing republic. And then this is the actual text of the HJR. And it's affirmed by Harold N. Stevens, Chief Judge of the United States Court of Appeals of the District of Columbia Circuit, in his article in the American Bar Association Journal, Volume 37, Number 4, April 1951, entitled Citizenship, the Real Profession of Every American. If our sovereign citizens are not informed upon such subjects, how can they intelligently participate in the determination of pertinent national policies? Therefore, we, the people, are the government. That's why it's called a republic. News releases stating that all sovereign citizens are terrorists is found in an ABC News article entitled Sovereign Citizens Terrorist Assessment Warns of Rising Threat from Anti-Government Extremists by James Thomas on 30th of November 2015, and in a news article on RT.com entitled As Sovereign Citizens Seen as Top Terrorist Threat by U.S. Law Enforcement by Brian Blanco on 5th of August 2014, and numerous other articles stating they intend to murder any sovereign citizen without a trial, without due process, by Obama's military police order followers. All the wrongdoers named herein are operating in support of Obama and his communist buddies to overthrow the republic, which is treason. Obama's weaponized Federal Bureau of Investigation even published a sovereign citizen quick reference in support of the Joint Terrorism Task Force, a true copy of which is attached here to it, Exhibit 19, all of which is incorporated herein by reference in its entirety. In an effort to exhaust administrative remedies and exercise Article 1 Amendment right to petition the government for redress of grievances starting in 2007 over a period of about 10 years, the demandant sent out thousands of notice and demands, almost all of them by registered mail, and the first paragraph of all of them says, I accept your oath of office. And in all fairness, most of the government officials the notice and demands were sent to were just honest, hardworking officials. A judge in Johnson County, Texas, returned a copy of his oath of office and surety bond, and a county sheriff in New York returned an insurance claim form. The demandant would never do anything to cause injuries to such honorable public servants because we need such people to keep the peace. And as said in the notice and the demands, that the demandant understands his duty to come to their aid when called upon. And this is talking about posse comitatus, the entire population of a county above the age of 15, which a sheriff may summon to his assistance in certain cases to aid him in keeping peace, pursuing and arresting felons. And that's Black's Law Dictionary, 6th edition. And will be there for them any time or any place. Pennsylvania Attorney General. On the other hand, the Pennsylvania Assistant Attorney General returned a letter saying that if the demandant drives in Pennsylvania without a driver's license, they would arrest the demandant and put the demandant in jail. The demandant took their letter with a copy of the notice and demand and made a 2-page criminal complaint and sent it to the U.S. Attorney in Harrisburg, Pennsylvania. 2 weeks later, they got a letter saying we've referred this matter to the FBI, and 6 months later, the Pennsylvania Attorney General's website showed they had an acting Attorney General, which means the previous Attorney General left office before his term was up. Now, I don't know if it had anything to do with me, but it probably did, but I don't know. On the 4th of August, 2025, about 9 p.m., the demandant was arrested by about 5 cars of the New Mexico State Police in a parking lot of the Crown Plaza Hotel in Albuquerque, New Mexico, after returning with a friend from dinner. The demandant was at an extraordinary science conference that he had gone to in early August for the past 7 or 8 years. The demandant asked to see the warrant, and they failed to produce it. While the demandant was in the back seat of the police cruiser, he heard an officer say, tell a name that I need that warrant. This is evidence that the weaponized Federal Bureau of Investigation and Texas Department of Public Safety, military, police intend that the demandant exercise the right to resist their unlawful arrest. Citizens may resist an unlawful arrest to the point of taking an arresting officer's life. Okay, lots of cases to support this. An illegal arrest is an assault and battery. The person so attempted to be restrained of his liberty has the right to use force in defending himself as he would in repelling any other assault and battery. Each person has the right to resist an unlawful arrest. In such a case, the person attempting the arrest stands in the position of a wrongdoer and may be resisted by the use of force, as in self-defense. Because they're required to produce the warrant when they make an arrest, or the demandant can resist their unlawful arrest. A special deputy is bound to show the warrant if requested to do so, and if he omits, does not, the party against whom the warrant issues may resist an arrest, and the warrant under such circumstances is no protection against an action for an assault, battery, and false imprisonment. It is doubtless the duty of an officer who executes a warrant of arrest to state the nature, substance, and cause of the charging process, which gives him the authority he professes to exercise, and if it is demanded to exhibit his warrant, that the party arrested may have no excuse for resistance. That's 1884. So the New Mexico State Military Police would have an excuse to murder the demandant, attempted murder, and conspiracy if he exercised the right to resist their unlawful arrest with lethal force if necessary, so they could shed some innocent blood for their handlers. And Brashear, Brandt, Lugo, Thomas, Simonton could justify their job and say the Joint Terrorism Task Force is doing their job to kill sovereign citizen terrorists, and the demandant would be dead. And who's going to say otherwise? A conspiracy results in liability for all those involved in false imprisonment or stripping a man of his rights for monetary gain. This is undoubted doctrine from the time of Marshall Sea case. And this is 1829 case, State of Connecticut versus Leach. There is also evidence of their illegal search and seizure in the demandant's property and the government's hearsay database and conspiracy with Casey Brashear because they knew where the demandant was, because of the license plate on the car he was traveling in, which the demandant has not admitted and does not admit as evidence, and no search warrants for hearsay electronic databases have been produced. Therefore, this court is required to presume that none exist. If the record does not show upon its face the facts necessary to give jurisdiction, they will be presumed not to have existed. Also, C, the law requires proof of jurisdiction to appear on the record of the administrative agency in all administrative hearings. Attempted murder. The Texas DPS military police actors have known for decades the demandant was involved with the Republic of Texas, as evidenced by their intelligence bulletin, full of hearsay information which was obtained in an illegal search and seizure in violation of Article 4 Amendment, and this is deliberate, calculated, attempted murder and war crimes, taking reprisals against the demandant and the people of the Republic of Texas for political beliefs. Ignorance of the law does not excuse misconduct in anyone, least of all a sworn officer of the law. And there's slander and defamation by the Texas DPS and the Tarrant County District Attorney and conspiracy with the Montana Highway Patrol and now the New Mexico State Police. Joint Terrorism Task Force are the terrorists. The truth of the matter is that the Joint Terrorism Task Force are the terrorists, fabricating terrorists for job security so they can shed some innocent blood for their handlers, which was they planned for the demandant. And then they get to pillage the fake money in the Treasury Direct account under GlennWinningham Fern under the Hague Convention concerning the International Administration of the Estates of Deceased Persons, concluded on 2nd of October 1973. And the demandant's not suicidal, but if he does turn up dead, this is deathbed testimony, or the demandant will be subjected to District of Columbia military prisons, just like what has already happened as described here, and then there are warrants that fail to be authentic, and the Roman law kangaroo courts. And that's that National Mutual Insurance Company versus Tidewater Transfer Company that we read earlier. Therefore, whether they enslave the demandant or kill him, resisting their slavery, either way, it's a win-win-win scenario for Brashear and his handlers. And the demandant later learned that on 5th of August 2025, Casey Brashear had knowingly executed an expired search warrant that was issued on 1 August 2025 by Alan Wayland, Grapevine Municipal Court, with 3 days to execute. And it says right here's the text on the warrant that says they have 3 days, and they did it on the 5th of August. Thereby conducting an illegal search of the house the demandant has been living in by breaking into the house, which is aggravated burglary, and pillaged property of the demandant and his roommates valued at over $200,000, and had arrested several people who were on a common law jury that had been conducted. A true copy of the warrants attached here to is Exhibit 18, all of which is incorporated herein by reference in its entirety. They had barricaded off all the streets nearby and make as big a spectacle as possible for the neighbors to see what happens, for their slander and defamation, with dozens of unknown officers who are busy hiding their identities to avoid the consequences of their criminal activity under the direction of Casey Brashear, Bobby LaPena, and Bobby LaPena, Bedford Chief of Police. The Bedford Chief of Police was also notified about the expired warrant. The Bedford Chief Police was there helping with the aggravated burglary, and the cowards failed to have name tags, and they have turned over all public information requests to their attorneys, obstructing the ability to get names of those involved. And they even told the homeowner when confronted about the expired warrant, "Oh, we do this all the time." Evidence the flagrant disregard they have for the requirements under the Constitution. If there's any organized criminal activity, it's Casey Brashear, Andrea Brandt, Leah Simonton, Marshall Thomas, Bobby LaPena and their criminal street gang military police with common identifying colors. On the 5th of August 2025, they held an arraignment in the Bernalillo County Jail and gave the demandant a copy of the fake warrant that failed to have a court seal as required by the Authentications Act at 1 Stat 122, which was the very first act of Congress in the second session, and is the supreme law of the land. Article 6, Clause 2, this Constitution and the laws of the United States which shall be made in pursuance thereof. True copies of the fake warrants are attached hereto at Exhibit 8, all of which are incorporated herein by reference in their entirety, and there were 3 felonies: organized criminal activity, terroristic threat, and terrorism. There are warrants that failed to be authentic, and fugitive complaint had the minor estate, name, date of birth, social security account number with the Treasury, all of which is hearsay evidence, and the defendant failed to admit any of it. Therefore, it's inadmissible, and evidence of their illegal search of the property in which the demandant has an interest in government hearsay databases. The demandant neither admits nor denies the validity of internet, but it's inadmissible because it's hearsay. And the demandant failed to admit it, and it was obtained with an illegal search and seizure of property in which the demandant has an interest in government hearsay databases. And no search warrants have been provided, signed by a judge acting as official capacity with a court seal, describing specifically what they're allowed to search for in the government's hearsay database. Therefore, the court is required to presume that no search warrants exist. The fugitive complaints are signed by Patrick Chavez, New Mexico State Military Police, a true copy of which is attached hereto at Exhibit 9, all of which is incorporated herein by reference in its entirety, in which Chavez says the minor estate, fiction of law, is a fugitive from TX, which is a military region in the District of Columbia that overlays the territory properly included within and rightfully belonging to the Republic of Texas, which was erected to a new state called the State of Texas, as evidenced by the Act of Congress 9 Stat 1 and HGR 1 dated 29 December 1945 and 9 Stat 108, and has been under martial law since 1861 when Galveston, Texas was invaded by the Union Army. And at the time the demandant was arrested, the demandant was a senator for the Republic of Texas because they're deliberately calculating taking reprisals for political beliefs, and they want the demandant dead. There's no evidence introduced by Lugo, Brashear, or the Texas DPS at any time in any case that the demandants involved in any contracts involving their minor estate. Therefore, the courts are required to presume that no such contracts exist. And presumptions that the demandant is dead. The power to create presumptions is not a means of escape from constitutional restrictions, and the power and presumptions that the demandant is dead to facilitate the use of trust law, which is part of the Pope's Roman law, cannot be used to escape from their constitutional requirements of their oath of office to the supreme law of the land, Article 6, Clause 2. The fake warrants are evidence that Steve Jones conspired with Casey Brashear, Captain Lugo, New Mexico State Military Police to threaten, coerce, intimidate, and injure the demandant in the free exercise of the right to engage in constitutionally protected activities, and holding a common law court, petition the government for redress of grievance, as well as violating the demandant's rights under color of law and attempted murder. A true copy of Captain Lugo's criminal complaints attached here to it, Exhibit 10. All of which is incorporated herein by reference in entirety. The demandant was arrested in a parking lot of the Crown Plaza Hotel, which is on the east side of the Rio Grande River. And this is important, which means the demandant was in the territory properly included within and rightfully belonged to the Republic of Texas, as evidenced by the Act of Congress, and I went through that already. And when arrested was at the time a senator of the Republic of Texas, and the New Mexico State Police unlawfully arrested the demandant, falsely imprisoned the demandant, kidnapped the demandant, attempted to murder the demandant, and conspiracy with Phil Storles, Stephen Jones, Casey Brashear, Captain Michael Lugo, Marco Thomas, Andrea Brandt, Leah Simonton for engaging in U.S. constitutionally protected activities of a common law court seeking a redress of grievance and exhausting administrative remedies. Under the Articles of Confederation, Article 5, Clause 4, because the demandant was at the time a senator of the Republic of Texas, the demandant is entitled to immunity from public statements, and the demandant is entitled to immunity from arrests or imprisonments because there is no common law crimes of the demandant, as evidenced by the fact that all the charges were dismissed. And this is Article 4, Clause 4. And there were members of the Republic of Texas executive branch of the Extraordinary Science Conference that the demandant was attending. And the Crown Plaza Hotel in Albuquerque and the New Mexico State Police caused a breach of the peace with their unlawful arrest, kidnapping, false imprisonment, and attempted murder, and conspiracy with Phil Sorrells, Casey Jones, Casey Brashear, Captain M. Lugo, Marshall Thomas, Andrea Brantley, and Simonton, and others. The fake warrants were also bills of pains and penalties, similar to bills of attainder, and unconstitutional because it named the minor estate and his date of birth, which is a fiction of law. A court of general jurisdiction is presumed to be acting within its jurisdiction until the contrary is shown, as evidenced by the judge who signed it was not acting as an official capacity. A court can be a court of general jurisdiction for some purposes and a court of limited jurisdiction for other purposes. When, therefore, a court of general jurisdiction proceeds under a special statute, it becomes a court of limited jurisdiction for the purpose of such proceeding. Where a court of general jurisdiction carries out a special power, decision made and exercise of such powers is treating a court of a court of limited jurisdiction, and the presumption applicable to a court of general jurisdiction that it acted within the scope of this jurisdiction does not apply. And that's Book 20 of American Jurisprudence, Section 103, Courts. It's familiar law that when a statutory authority in derogation of common law is conferred on courts of general jurisdiction, such a court of general jurisdiction becomes quad hoc. Quad hoc means for the purpose of this proceeding only, a court of inferior or limited jurisdiction. Because he was legislating from the bench under Roman law, fictions of law. This is taken from Bouvier's Law Dictionary, 1856 edition, volume 1, page 520. Fictions were invented by the Roman praetors who, not possessing the power to abrogate the law, were nevertheless willing to derogate from it under the pretense of doing equity. Fiction's the resource of weakness, which, in order to obtain its object, assumes a fact which is known to be contrary to the truth. See, they presume you're the fiction. When the legislator, so they're a legislator when they do that, okay? It's a legislative act. When the legislator desires to accomplish his object, he not feign, he commands. Fictions of law or their origins to the legislative usurpations of the bench. Because a bill of pains and penalties, similar to a bill of attainder, is a legislative act that applied to named individuals to inflict punishment without a judicial trial. And that's taken from U.S. versus Lovett. Legislative acts, no matter what their form, that apply to either to named individuals, me in that case, or to easily ascertainable members of a group in such a way as to inflict punishment them without a judicial trial. Because judges only hold office during good behavior, and engaging in legislative acts from the bench is bad behavior and derogation of common law, the judges, both the Supreme and inferior court, shall hold their offices during good behavior. Article 3 judges are neutral and unbiased. It's a fundamental rule of a party to have a neutral and detached judge preside over judicial proceedings. And only an Article 3 judge can make decisions about life, liberty, or property. And this is 2023. Cases involving deprivations or transfers of life, liberty, or property constitute a core of cases that must be resolved by Article 3 courts, not executive administrators dressed up as courts. And this is that's in 2023. This is 1933. Where controversies of such a character as to exercise the judicial power defined by Article 3, jurisdiction thereof can be conferred only on courts established by virtue of that article, and Congress is without power to vest that judicial power in any other judicial tribunal, or of course in any executive office or administrative executive board, since they are incapable of receiving it. So the judge himself is incapable of acting in that capacity. And then there's a whole bunch of court cases in support of that. Judicial functions cannot be delegated to non-judicial entities. Non-Article 3 courts must operate under judicial supervision. That's why they have a magistrate in the federal courts. Anyways, there's a bunch of court cases right here that talk about it. Therefore, Stephen Jones was purporting to be a judge in a court and was impersonating a public servant, which is a Class 3 felony in Texas, and was part of an attempted murder conspiracy when the demandant exercised the right to resist their unlawful arrest with lethal force if necessary. Stephen Jones also signed Kenneth Ouimet's fake warrants, and they also failed to be authentic because there's no court seal as required by the Authentications Act, which is the very first act in the second session and is the supreme law of the land. And they are also bills of pains and penalties for the same reasons the fake warrants are bills of pains and penalties from the defendant's case. Therefore, Stephen Jones was impersonating a public servant in violation of Texas Penal Code 37.11 when he issued the fake warrants for Kenneth Ouimet. And it's also part of a conspiracy to threaten, coerce, injure, intimidate Kenneth Ouimet in the free exercise of constitutionally protected activity of holding a common law court. And Ouimet had the right to resist that arrest with lethal force if necessary. Therefore, it was also attempted murder. True copies of the fake warrants used to falsely arrest Kenneth Ouimet are attached here to as Exhibit 11, all of which are incorporated herein by reference in their entirety. The fact that there is no court seal as required by the Authentications Act fails to be a curable defect because the arrest has already taken place, and in the defendant's case, they admitted to not having the warrants when making the arrest, which means they failed to know that the warrants even looked like or what it said, which means they failed to care if it was a lawful warrant, which means it was deliberate, calculated, malicious, attempted murder. Ignorance of the law does not excuse misconduct in anyone, least of all in a sworn officer of the law. By Stephen Jones, Phil Sorrells, Casey Brashear, Andrea Brandt, Captain Michael Lugo, Leah Simonton, Marshall Thomas, and all the officers of the New Mexico State Police involved. The defendant waived extradition without prejudice, and this is how you do this, and I can show you these documents if you want to see them. The defendant waived extradition without prejudice, which means there's no contract, no waived rights, and no evidence, and gave no evidence against himself. And a U.S. Marshal brought the defendant to Tarrant County Jail in Fort Worth, true copies of which are attached here to as Exhibit 12, all of which are incorporated herein by reference in their entirety. Because the defendant signed the extradition waivers without prejudice, they failed to be authorized to pay for the false arrest, assault, kidnapping, false imprisonment, attempted murder, extradition from the minor estate treasury direct account. And Phil Sorrells paid for it from the treasury from Tarrant County public funds, which means it's also a misappropriation of public funds. Because we flew to Houston, and then the U.S. Marshal rented a vehicle, and the U.S. Marshal told the defendant he made his living doing extraditions. U.S. Marshal, he would have no trouble from the defendant because the charges were completely spurious, and the defendant did not want to add real charges to the fake charges. And when dropping off the defendant, the U.S. Marshal thanked the defendant for his cooperation during the trip. On 11th August 2025, the defendant was arraigned at Fort Worth, given a $500,000 bond with onerous, egregious, punitive bond restrictions like GPS ankle monitor, no internet, home confinement, which is signed without prejudice, which means there's no contract, waived no rights, admitted no evidence, a true copy of which is attached here to is Exhibit 13, all of which is incorporated herein by reference in its entirety. Furthermore, because the defendant signed everything without prejudice, and the guards were asking some of the other prisoners, why is he putting without prejudice here? Because that was done literally every time the defendant was given something to sign, including the forced medical experiments. Therefore, they failed to be authorized to pay for the false imprisonment from the minor estate treasury direct account, and Phil Sorrells paid for it from Tarrant County public funds, which means it's also misappropriation of public funds because the defendant is sure that the Tarrant County Jail is a for-profit business. The Greek derivative of the word sorcery is pharmakeos, and the Tarrant County Jail has a whole floor dedicated to Satanists peddling their pharmaceuticals with their forced medical experiments. The first thing they did was take blood pressure, and then it was continuous harassment to take blood pressure because they said the defendant had high blood pressure, even threatening segregation and forced medical experiments with a high blood pressure because the defendant might have a stroke. The defendant told them that he read an article about how stroke symptoms are very similar to symptoms of vitamin C deficiency, which is scurvy. But the hospitals and medical doctors make no money selling vitamins and had none because the defendant asked for vitamin C. And the jail food is completely devoid of vitamins, and the defendant had to beg other prisoners for their orange peels because sometimes they would work as trustees in parts of the jail where the reward was an old dried-up orange. But orange peels are almost pure vitamin C, and the defendant would beg for orange peels so he could eat them and get a little bit of vitamin C, because it was certainly not in the food, and the sorcerers would love the defendant to start exhibiting symptoms they could claim are stroke symptoms so they could peddle their pharmaceuticals. On the day before the defendant was released, he filed a grievance for their forced medical experiments and wants it listed here as a war crime. It got to the point they would wake the defendant up to get blood pressure taken, and then when refused, they would make the defendant sign for it, And the defendant would assert without prejudice, and then would have to get into an argument about the signature and have to explain to their hired thugs that Title I, Section 1 of U.S. Code says signature is a mark. And it can be anything, even the smallest dot or a smiley face. And for this, it's a without prejudice. Around 21 August, a court-appointed lawyer, Valerie Vale, came to see the defendant in the Tarrant County Jail and offered a plea bargain in the matter. The defendant accepted her offer. The defendant sent Valerie Vale 2 letters from Tarrant County Jail, the first one on or about 25 August 2025 with an affidavit of fact explaining what we were doing with the common law court, and the defendant was previously charged d'affaires with the Republic of Texas, which is equivalent to an ambassador, and had lifetime diplomatic immunity protection under international law, and also had immunity from public statements under Articles of Confederation, and a motion for an identity hearing to establish that the defendant is not lost at sea, is not their minor estate, is a man on the land of Texas, to remove the defendant from trust law, which is part of the Pope's Roman canon law. And the second letter, on or about 2nd of September 2025, explained that the defendant was going to have a friend get a certified copy of a Document 113, Affidavit of Life, and a Document 112, Mandatory Judicial Notice of 12 Presumptions, from Federal Court Case 424 CV0881, for the lawyer to introduce as exculpatory evidence into the evidence file, and a motion to quash the warrants because they failed to be authentic warrants, which would make the arrest unlawful and illegal, and everything that precipitates from an unlawful illegal arrest is also unlawful and illegal, precipitating dismissal of the case. A true copy of the affidavit of fact as Exhibit 14, the motion for an identity hearing as Exhibit 15, and a motion to quash the warrants as Exhibit 16, all of which are incorporated herein by reference in their entirety. On 17 September 2025, Valerie Vale came to see the defendant in the Tarrant County Jail and told him all charges were dismissed, evidencing it was a malicious prosecution. Although probable cause may not be inferred from malice, malice may be inferred from lack of probable cause. And if they dismissed it, then they didn't have probable cause. Because when a legitimacy of the arrest is disputed, it's presumed to be unlawful, and the burden of proof shifts onto the officers making the arrest. The only thing the plaintiff needs to do is allege a false arrest. Is either 1, that the defendant made an arrest or imprisonment, or 2, that the defendant affirmatively instigated, encouraged, and incited to cause the arrest or imprisonment. So all you got to do is say there's a false arrest going on, and now the burden of proof shifts. When the plaintiff has shown that he was arrested, imprisoned, or restrained of his liberty by the defendant, the law presumes it to be unlawful. The burden is upon the defendant to show that the arrest was by authority of law. Any arrest made without a proper warrant signed by a judge, backed up by an affidavit from 2 persons that states under penalty of perjury you've broken a contract or hurt someone if challenged by the defendant, is presumptively invalid. The burden is upon the state to justify it as authorized by statute and does not violate constitutional provisions and or human rights. In the case of an illegal arrest, the officer must keep within the law at his peril. The defendant was released on 18 September 2025, a total of 45 days after being assaulted, kidnapped, falsely imprisoned, and the defendant's murder attempted in New Mexico in conspiracy with Phil Sorrells, Casey Brashear, Leah Simonton, Andrea Brandt, Stephen Junes, R. Joseph Rothrock, Marshall Thomas, Captain Michael Lugo, and Patrick Chavez and his New Mexico State Police buddies. The defendant picked up his car in Albuquerque in New Mexico on the 22nd of September, and it cost $1,064.62 from the storage company, as well as over $500 for a rental car for a week and $500 for Darren Swain to travel to Albuquerque to bring the car back. The defendant later learned that Chris Johnson, judge of Hays County Court at Law 2, issued a fake warrant that failed to have a court seal to search the car in Hays County on 1st of August 2025, a true copy of which is attached here to it, Exhibit 17. All of which is incorporated herein by reference in its entirety. Therefore, Johnson was purporting to be a judge and a court, evidencing he was impersonating a public servant. Also, Phil Sorrells, Casey Brashear, Leah Simonton, Andrea Bryant, Stephen Junes, R. Joseph Rothrock, Marshall Thomas, Captain Michael Lugo, and Patrick Chavez and his New Mexico State Police buddies are subjecting the defendant and the people of the Republic of Texas to their satanic religious ceremony, assaulting us with their minor estate, which is necromancy, fraud, deception, and idolatry, which is another war crime. The defendant found out that all the charges against the common law court jurors were dismissed as well, evidencing the whole thing was a malicious prosecution by Phil Sorrells, Casey Brashear, Leah Simonton, Andrea Brandt, Stephen Jones, R. Joseph Rothrock, Marshall Thomas, Captain Michael Lugo, in support of their slander and defamation to terrorize we the people of the Republic of Texas into refraining from constitutionally protected activity, to justify their work as joint terrorism task force, and make work for themselves by creating terrorists so they could shed some innocent blood for their handlers. Further evidence they are actually the terrorists, conspiring to threaten, coerce, injure, or intimidate anyone on the common law court in the free exercise of our right to engage in constitutionally protected activity of holding a common law court under color of law, as well as violating the defendant's rights and the rights of everybody on that jury under color of law, as well as attempted murder for every fake warrant executed. Anyways, let's see what's happening on YouTube. What I would suggest for the foreclosure case is contact Rule of Law Radio. Wow, it's been going on. This has been going on for an hour and 20 minutes. Does anybody have any questions? I'm not sure that I want to go through the rest of this.
I do.
Okay.
But I'm based in Glen. I'm based in Australia. And I've been coming in and out because of multiple phone calls that I've been having. But basically in Australia right now, my case has progressed, but some things good, some things not. So I have exploratory evidence that I was basically, what happened is my father was killed by the medical system, and they are trying to frame me with it. I've been asking people who deal with trust law to help me to know availability, if that makes sense. So basically now I have evidence about the prosecution coming towards my lawyer, putting pressure on him and saying that we are going to remove her bail conditions, which my bail conditions I've never, faulted on or anything like that. They're saying that they want to lock me up, put an order that stops me from, I'm a flight risk, basically, which I haven't even shown any evidence for a whole year. And so that I haven't shown that I'm a flight risk to anybody. They have I have the police on recording, the prosecution clearly stating to my barrister that they want me dead, either inside or outside. I don't know. I've become apparently the enemy of the state since I became a whistleblower against child abuse from Montessori Academy. And now the next thing that in 2 weeks' time, they are putting a charge order when I have all the evidence. But every time I try to produce the evidence to my barrister, he goes, "You can't give me nothing because I don't even have a brief." And they're waiting on a post-mortem report about the causation of my father's death. Why has it taken a year for you guys to even produce it? And second of all, I said to them, "What is my father's blood type?" Because I know what my father's blood type is. And I have all my father's medical records because my father was, I had a guardianship over him in the private, not in the public. And they overrode my private jurisdiction, and they took my father. They tried to make him incapacitated, which they did, and they killed him in the hospital. And I don't know if they even took his organs.
And you might want to mute out. Glenn, you might want to mute out when someone's talking to you because there's so much reverb.
I've muted, darling.
I was talking to Glenn.
Okay, yeah, I appreciate you letting me know that. You're right. I forgot about that. Now, so well, there's several things that, in my opinion, that you're not doing right. First of all, you have a lawyer. Now, the lawyers can be useful if but you gotta run that lawyer. And like with that lawyer that I had, I actually filed a bar grievance against him, and they were pissed when I told them that. But my attitude is that they're working for me. They're not working for the court. And your lawyer is working for the court right now. And so I would file a bar grievance. I would file a bar grievance against his ass. And when he's in there begging to get off the case, then you just tell the judge is going to ask you if you want him on the case or not. And so the strategy, in my opinion, is to tell him you want him on the case, but you want him to do his job, and that gives him plausible deniability in front of the judge to do stuff for you. Mm-hmm. There's a guy, Randy Kelton talks about that in one of his radio programs, and he said that he did that one time, and the lawyer, he tells the lawyer when they're leaving, if he doesn't get the thing dismissed, he's going to get him, bar grieve him again. And 4 hours later, he gets a phone call. This is a public pretender too. He gets a phone call 4 hours later. The public pretender is all excited. The case got dismissed. It's the first case he ever won. Mm-hmm. So anyways, I would say you got a problem with the lawyer, first of all, and I'd start filing war crimes complaints. There's Australia has acceded to the Rome Statute, so you got to build a case against them. But if they're forced medical experiments with your father, I'd file war crimes complaints against them. And it's amazing how shit will start to happen when you start doing that stuff. There'll be people making phone calls.
It was a war crime. It's Glenn. It was a war crime because I'll tell you why. My father's hold on, stay with me. My father's birth certificate and all of that, it showed that I don't know if you guys looked into the social media. It was the time where Bankstown Hospital were killing Jewish people off their passport. And my father has a Jewish passport, even though he's a Christian, right? So they were killing people in the hospital if you had any form of Jewishness or Star of David.
Yeah, that's fine. So you got to build a case.
Connection.
You got to build a case, and I would send them to the Hague in the Netherlands, because that's where the Rome, the International Criminal Court's located, and I would be filing war crimes against them. And
would that be international arbitration or international criminal courts?
I don't. I just send it to the prosecutor, and what'll happen is they'll have to investigate it. And so I'm not interested in some settlement. I want somebody arrested and prosecuted. And I can tell you that I filed war crimes complaints. There's a friend of mine that his wife is a nurse at the MD Anderson Cancer Center in Houston, Texas, and this was back in 2022 or something like that. She gets an email and it said, "Prepare to take the jab or prepare to be terminated." And so I went and filed war crimes complaints against. There was the MD Anderson Cancer Center is owned by the University of Texas, and the University of Texas has a board of regents, and there's 3 lawyers on the board of regents and a chief counsel. So the lawyers are always the low-hanging fruit. Is accuse the lawyers of it. In your case, find out who's the head lawyer involved in your case, and accuse him. And anyways, because the lawyers are deemed to know the law, and so I filed 4 criminal complaints against those 4 lawyers, 1 for violating her rights under the color of law, 1 for conspiracy, 1 for satanic, because they were offering her a medical exemption, but you had to fill out a questionnaire. Well, her religious beliefs, or I should say a religious exemption, her religious beliefs are none of their concern. And so that's about another war crime. And it was forced medical experiments. And so I went and sent those 4 criminal complaints, And 2 weeks later, she gets an email. She'd been granted a religious exemption, and she hadn't even applied for a religious exemption. And then 2 weeks later, they came out and they said, well, if you want to take the jab, you can. Otherwise, don't worry about it. And so, if you don't, you gotta bring up the right issues. And that's what I'd be doing if I were you. As far as stuff in the public.
I know that they killed my dad. Glenn, because when I went to visit him in the hospital, they had put a conservatorship on him, which stopped me from being able to visit my dad. Every time I wanted to go and visit my dad, they'll bring the police until I started getting a magistrate to change and appeal certain things, to the point where I went and saw him on the day that he died. My dad was responsive. He was talking, but he had tubes in his mouth, so you couldn't really hear exactly what he was saying, but he was fully cohesive in understanding everything that I was saying. Then I see a motherfucking huge injection beside his bed table, filled with liquid. And I said, what the fuck are you going to do that? They were like, oh, that's for his operation that we conducted on his back. Okay? And in my heart of hearts, I said to my mom, they're going to kill Dad. They're going to kill him, and they're going to use me as a scapegoat. They're going to kill him. And I was right. 5 minutes later, my mom says to me, they gave him an injection in your dad. They took the tubes out of your dad's mouth. He's dead.
Yeah, well, I'm not surprised. I don't let myself get into those hospitals, quite frankly.
He had no option, because what happened to my dad is he had a neurological degenerative discs, and he had a titanium cervical, he had titanium plates. And the first operation that he had back in 2010, after the fall that he had, it was degenerating. The operation wasn't fully successful. So every 15 to 20 years, it needs some form of revisitation, but not like this.
Well, yeah.
And they're claiming that I broke his neck, fabricating things against me. I'm like, well, first of all, I wasn't even in that location, number one. Number two, how can you break titanium?
All I know is, I wish I could tell you more. I don't really have an answer for you. I don't get myself into those kinds of situations. They were trying forced medical experiments on me, and so now I'm going to file a lawsuit against them. And what I would like to see happen, and we'll see. I don't know if it'll happen or not, but next time they try and take me down to that jail, the county sheriff comes down there and says, we don't want you in our jail. Get the hell out of here. I'm hoping that happens.
Yeah, that's exactly what I'm trying to learn. How do I do that in Australia? Because in America, you guys have, your laws are very, very different. We have the shit crown that we have to deal with.
I know you're under crown, and it's bad.
It's very bad.
I agree.
You have no idea what they're doing right now in Australia. They're coming for the children and the single moms. They're making every fucking excuse to every single, this is now, the government has just passed through today legislation, right? Since yesterday, okay? That single mothers are going to be investigated by the police in like what they're doing in America with the food stamps. Okay, who are dependent, their utility payments are going to be removed. What is happening right now in America, it's happening here. What I'm looking for is to have my case dismissed, put a restraining order against the police that they don't harass me, because I have been sexually, indecently assaulted by police whilst under arrest and being accused of resisting arrest.
Yeah, I don't know what to say. I mean, I feel for you. I know I grew up in Canada. Okay, so I know what the communists are like, and Canada is not much different from Australia. And I wish I could tell you, what to do. If you can find a remedy, there's actually it's called Matrix Freedom. That's a website that I'm involved in. They're in the UK. And they have some pretty good remedies. and I would suggest, I would suggest go there because they have developed ways of getting remedies, but it's completely.
Yeah, absolutely. If anyone can help me get connected, because I'm starting to have PTSD symptoms. Like, yes, 2 days ago, I felt suicidal. I've never felt any in my whole life suicidal. I gave up hope on living until I went and saw my son. I was like, no, I have to live for my son. And I'm not the person who ever gives up. But it came to the point where it was like, I couldn't handle it anymore, to the point where the police were constantly harassing me. And I was, I had the lawyer like berating me and belittling me in fucking court. So I shut my mouth and I'm like, I'm going to cause a scene, because I'm not the type of woman. I'm not like a person who's just going to go in a local court and start causing. He's trying to create a character and a narrative that is not my character. So I was like, I am looking for somebody to help me, and whatever we get, take it all. I don't care. Just give me back my child, number one, and give me back my freedom.
Yeah.
Does that make sense? My freedom. I don't care about the money.
I understand completely, but and the only thing I can tell you is you got to be careful what you tell them. I wouldn't tell them that you want to commit suicide, because they'll put you in a mental institution, and then they will start putting forced medical experiments on you, and there won't be a damn thing you can do about it. So I wouldn't be telling them.
No, I didn't. I haven't. I haven't. They actually have put a conservative.
Anyways,
they actually put a conservatorship on me without any medical evidence.
Okay, well that's good. I feel for you. I wish there was something I could do or say. There's really I'm in the we have our problems here in America, but they pale in comparison to elsewhere. I know that for a fact, and I feel for you. I wish there was something other than coming here, but here, even here, it's difficult. The whole world is under attack by these Satanists. This is literally a war of good versus evil, and so what I would say is pray to God for help, because God will help you out. That would be what I'd say, is ask for inspiration on what to do and how to deal with it, and that's to be led to the right people. And God will help you. I know for a fact that He does. When I was arrested, I had this feeling come over me that this is going to be the best thing that could ever happen, and I can see that's exactly what's going to happen. I had that feeling, and then when I was in the Albuquerque jail, I had deja vu big time. I was like, I've been here before. So I know that God is around, and that there's intervention, and that we have a destiny. We all have a destiny, and so what I would say is pray to God for help. He can help you. He definitely can, and He will. And so yes.
Would you put that website that you suggested for her in your chat, please?
Sorry?
Will you put that website that you suggested for Catherine in your chat, please?
Sure.
Thank you, Eye of the Earth.
Glenn, I have a quick question. If you will, I just want to know, along with this complaint, will you be including the exhibits along with, please?
Sorry?
I just have a quick question. I was wondering if you're going to include the exhibits along with your complaint when you post this, please. And please post this, please. Thank you.
Did you hear Mary asked for the exhibits?
I heard. What I would suggest is
or the table of exhibits would be good enough if you don't want to redraft it all.
The exhibits. Now, I can put. Let's see. Did I put them in there already? I think I might have last week. Oh, I put the search in there. Okay. Well, I'll put some of them in there. I got the affidavit of life is in there. Mandatory judicial notice of 12 presumptions is in that in my chat on the group. The exhibits, I can put them in there that show that I signed without prejudice. Let me see here. Let me. I got to do that right now while we're talking, or I'll forget.
Yeah, do that. And Catherine, please check your DM for me.
Thank you. Added.
And I'll upload the Word file. I'll do that while we're talking here. Otherwise, I'll forget.
Thank you. Edley, the hostess with the mostest. Do you have a great joke for us this week?
I was going to ask you, darling, and I had to thank you for pointing out Glenn's error on his paperwork because he did exactly the same thing to me 9 years ago.
I did what?
You looked over my paperwork and you talked about my I's not being correctly spelled, which was a Word document issue, and anyway, that glitched me out. So Mary got you back for me. There you go, Glenn.
Well, that's interesting. That's been a couple times. I've slept a couple times.
If Glenn doesn't mute out when people are talking to him, this recording is gonna suck for everyone to listen to later.
Thanks for the reminder on that.
Okay, I'm putting the stuff up. I'm putting up there has been redacted, so I took out the personal information out of there.
Okay, well, if you mute up, I'll ask if somebody better at joke telling has a good one. But you gotta mute up.
Oh, okay. Just a second.
Okay, shit, Mary, you gotta give us a good joke because I don't have one. I'm burnt this week.
Okay, I'm muting now.
I am the world's worst joke teller, but here's one. Okay, so a man takes his dog to the vet. Sick dog. Vet gives the man some medicine, and the man comes back a week later and says, "Hey, my dog won't take the medicine." Vet's like, "No problem. Stick it in some cheese." So, no problem. Dog gets healed up. Great dog. Good doggy. Week later, his wife starts menstruating. He says, "Honey, would you please take a Midol?" She said, "If I have to suffer, so do you." He says, "Okay." "Oh, honey, oh, lovey, would you like some cheese?"
I beg to differ. You're a much better joke teller than I am. I'll try not to laugh out loud. Us Irish girls are really bad, Glenn. You gotta get used to it. I'm sorry. No, we're not bad. Anyway, thank you for displaying all of the affidavit and pointing out how you've changed it up a bit. I had some questions regarding how when you were a senator, what was the oath-taking process for you? And you don't dare answer it now. I know that'll be long and drawn out, and you've been here for long enough. But maybe next week you can get into that for us, just so we can know what that process was like for you. And well, we know that you certainly do stand on your oath, and I just wish there were many, many more that were made like you. So thank you for coming. Have a great weekend, and we will talk to you next week, same time, same place, right?
So yeah, so you asked me the question again about the oath-taking process? What's that? Oh.
Are you saying goodnight because you're muted? Shoot.
I am muted, and I was trying to talk to you. That's what happens. I forget I'm muted. Anyway, so you wanted to know about the oath-taking process?
Also, well, yeah, as being a senator, you took your oath.
I did, to the Republic of Texas.
Who did you have to file it with? And what other documentation goes along with a lawful oath, if you will, please? And what oath did you take?
To the Republic of Texas. It's Republic of Texas. So it was kept with the Secretary of State, and that's Republic of Texas, completely internal Republic of Texas stuff. But yes, I did take an oath to the Republic of Texas. I took that oath a bunch of times, actually. And there was periods of time when they wanted us to take 2 oaths, which you know, there's a lot of actually countries that require to have 2 oaths. There's an oath of office and an oath of allegiance. And so there was periods of time when I had to take 2 oaths, which, you know, you just do what you have to do. But yeah, it was to the Republic of Texas and to the Constitution of the Republic of Texas. And so it's not filed with the United States or anybody like that. It's completely internal to the Republic of Texas.
Not to God, unfortunately.
Well, you know, God is in there. I mean, I don't have the oath in front of me, but I think it does say, "So help me God." I mean, it's been a while, and I have since resigned that position because I got into a dispute with them. They didn't want to do anything to help me in this situation, so I'm basically on my own, and so. I'm not going to badmouth them here, but so I did get into a dispute with them, and I resigned, and so they can find someone else to do it. But so at any rate, it's about time probably to end this. It's just been about 2 hours. It's an hour and 47 minutes that we've been doing this. So. Why don't we let's go ahead and end it? Does anybody else have any questions or anything about this particular? This is a lawsuit that I was getting ready to file, but there's a lot of stuff. There's going to be a lot of changes to it. This is a lot of the issues that are here. We've already talked about. The important thing is that the Republic of Texas does exist. And the United States is in treaties to recognize the Republic of Texas, and so I think that we're going to have some military police. I think we're going to get them in some free room and board in Crowbar Hotel, but we'll see. You know, that's all I can say. But you could see from some of the arguments that I was bringing up that they're going to have a problem. At any rate, if anybody's got any questions, this is the beginnings of a lawsuit that's going to be brought in federal court. It's federal court, can't be in state court. It's got to be federal because the federal court has jurisdiction over war crimes. If nobody's got any questions, then I guess we'll sign off and we'll same time, same place, same channel next week. Yeah, I'll be back in Texas by then, and we can do it in Texas.
Sounds
Real
good. Don't be
quick.
late.
All right.
After you get out of federal, will this be a tort claim as well? Will you
I don't
have
know.
to bring it to tort?
It might be. Randy suggested I get 2 books. One is O'Connor's. O'Connor's is a law book company, okay? And so O'Connor's Causes of Action and O'Connor's Civil Trials. It might be a tort claim. I don't know. I've never really brought anything as a tort claim. I just tell a story. But Randy is telling me that there's I need to improve and make sure that this thing is going to fly, and that we kick their butt around the block. Then I need to get information out of those books. And so those books are sitting there waiting for me in Texas right now. And once I get them, I'm going to be going through them and making adjustments to this lawsuit based on what those books are telling me. And because the books, the stuff that's in the books is the way the judges are expecting to see the lawsuit. So you want to try and make it as much how they're expecting to see it as possible. And excuse me, that'll give it a lot of power. So, I don't know. I'm going to have to wait and see what those books tell me.
Is our O'Connor's books only good for Texas? And funny thing, haha, I'm an O'Connor, haha.
Well, I don't know. I would guess that they probably are, but I don't know. What I would do is, Randy has a Telegram app called, let me find it. He's got a Telegram, let me see here. Telegram group. It's called The Law Society. That's Randy's Telegram group. There's like about 5,000 people on it. Oh, it's only 2,214. So, but that's Randy's Telegram group. What I would do is contact him, because he's done stuff in other states too. And tell him what state you're in, and tell him what books that he recommends that you get to prepare a lawsuit. And there'll be other people.
Unfortunately, it's not a public group. I just typed it in the Law Society, and I cannot see it. But thank you. Maybe you could share the link, or ask if you can share.
Okay. Let me see if I can. I know you're on my group. You're on my Telegram here. Because you sent me some stuff in Telegram. Okay, I'll see if I can. If I don't send anything to you, remind me, okay?
Thank you, Glenn.
Okay.
I love this program. Thank you. I appreciate you very, very much.
All right, it's a networking thing, so we have to share what works, and so that's what we're doing, and that's what God wants us to do, and so we help each other. It's a networking thing, so glad to help. Okay, if there's nobody else, then I'm going to go ahead and close out here, and we'll see you next week, same time, same place, same channel.